Hi guys, welcome back to my channel. Welcome to my channel if you're new here. I hope you're having an amazing day wherever you are, and I hope you're staying safe. In today's video, we will be talking about Form I-864, also known as the Affidavit of Support. But did you know that there are also Forms I-864A and I-864EZ? And it can be very confusing trying to figure out which form you should be using and who should be signing each form. This video will probably be very long, but I promise you that I will answer most, if not all, of your questions. So please make sure that you watch the entire video and check out the description box of this video where you will find specific timestamps for each question. And also check out a playlist I have on my channel related to all things immigration. Form I-864 is a legally binding contract. By signing this form, the sponsor agrees to provide financial support necessary to maintain the intending immigrant at an income of at least 125% of the federal poverty guideline. Poverty guidelines are different depending on the family size, also known as the household size. And you can find different poverty guidelines on the USCIS website. Once this form is signed, the sponsor will be financially liable for the intending immigrant until either A, the immigrant naturalizes and becomes a US citizen, or B, the immigrant drops out of the process entirely. There is no fee for I-864 because it is a necessary part of your adjustment of status application, and you will be including it together with your Form I-485. I will not be going over Form I-864 step by step. However, we will go over some of the most confusing parts of this form. Right off the bat, the first part where people typically make a mistake is part 1, question 1. As you can see, there are many options here, so which one do you select? Let's look at them one by one. The first option is 1A. I am the petitioner. I filed or am filing for the immigration of my relative. You will select this box if you were the original petitioner on the immigrant's I-130 application, which is petition for alien relative, or I-29F application, which is petition for alien fiance. Keep in mind, though, that if you are a US citizen petitioning for two different immediate relatives, such as, for example, your spouse and your child, then in that case, you will be submitting two forms I-864, one for each of your immediate relatives. Option 1B. I filed an alien worker petition on behalf of the intending immigrant who's related to me as my blank. So you will be selecting this option if you are submitting an employment-based petition for your relative. For example, your spouse, parent, child, son or daughter, brother or sister, right? This will be only an option for petitioners who submitted Form I-140. Moving on, option 1D. I'm the only joint sponsor. Let's talk about what it means to be a joint sponsor. A joint sponsor can be anyone who is a US citizen of 18 years or older who lives in the United States. It can be a friend or it can be an independent family member who does not reside in the same household as the petitioner. There is a huge difference between being a joint sponsor versus being a household member for the purposes of this form. I will explain the household member's responsibilities later in this video. If the petitioner is unable to meet the 125% requirement of the poverty guidelines, they still will have to submit Form I-864, but now they can also enlist a help of a joint sponsor who can meet this income requirement. Joint sponsor has to submit a separate Form I-864. The joint sponsor must be able to meet the 125% requirement of income for the poverty guidelines to cover both the intended alien and their own household as well, the joint sponsor's household. So basically, later in this form, we will be looking at how to calculate the household size, and the intending immigrant will be included in the sponsor's household size. So keep that in mind as well. Another important thing is that a joint sponsor cannot combine their income with the petitioner's income or another joint sponsor's income. So when it comes to using a joint sponsor, your income as a petitioner basically becomes irrelevant because you cannot combine those two. So basically, a joint sponsor will bear the majority of the financial responsibility for the intending immigrant. Now let's look at the option 1E. I'm the first or the second of the two joint sponsors. So, like I said earlier, there can be up to 2 joint sponsors. This is usually the case when more than one immigrant is immigrating to the United States at the same time or within the 6 months period. In this case, each of the 2 joint sponsors will be responsible for separate immigrant. For example, if a family of 4 is immigrating, for example, petitioner's spouse and 3 children, the first joint sponsor, say joint sponsor A, will include the spouse and one of the children on their affidavit of support. And then the other joint sponsor B, will include the other 2 children on their affidavit of support. So instead of one joint sponsor trying to support 4 immigrants plus their own family, which may be way too difficult to make necessary income for that, using 2 sponsors will split that responsibility. However, once again, I want to remind you guys that joint sponsors cannot combine their income between each other, or they cannot combine their incomes with the petitioner. And finally, option 1F is for substitute sponsors if the original sponsor is deceased. Okay, part 2. In this part, a lot of people trip up because they assume that they have to include their own information as the sponsor. However, this part is asking for the information about the primary immigrant, so make sure you read this part carefully. Moving on, part 3. For question 1, right here, I'm sponsoring the principal immigrant named in part 2, yes or no. You will select yes if you are sponsoring the primary immigrant. So for example, if you are a petitioner and you're sponsoring the primary immigrant, you will select yes. You will only select no if you are the second of the 2 joint sponsors and you're sponsoring the primary immigrant's family members. So like in our previous example, joint sponsor A would be, for example, sponsoring the primary immigrant, a spouse, and then 1 child. They will be selecting yes to this question. And then they will be including the first child in the family member part right here down below. Okay? However, if you are the second of the 2 joint sponsors and you are sponsoring the 2 other children that are coming along with the primary immigrant, then you will be selecting no. You will also click no if you are sponsoring principal immigrants' family members who are immigrating more than 6 months after them. Okay, part 3, question 2. You will only select this if you are sponsoring family members of the principal immigrant that are immigrating at the same time or within 6 months of the principal immigrant. So, for example, if you are a US citizen and you filed I-134 your sibling, your sister, for example, and her husband and children are also included in your sister's green card application as her dependents, Then you will put their names in the family member 1, 2, 3 in the following lines. This is only for those family members who are planning to come to the United States with the principal immigrant at the same time or within 6 months period. However, if you are a US citizen or a green card holder and you are petitioning for your spouse and your unmarried child under 21, then you should have already filled out separate petitions, separate I-130s for each of them, and therefore you would be filing a separate I-485s for them, meaning separate I-864s as well. Okay, part 3, question 3. I'm sponsoring the following family members who are immigrating more than 6 months after the principal immigrant. So you would only select this again, like I mentioned in the case with your sister, for example. Say her husband and children are immigrating after 6 months, typically because for family preference immigration, it takes such a long time. It would be very rare that you would be selecting this, but it does happen in some cases. To summarize again, if you are the petitioner, you don't have any joint sponsors, you're the only one sponsoring your, say, spouse, you will be only selecting one yes and nothing else because nobody else is coming with your spouse, okay? Moving on. Part 3, question 29. Enter the total number of immigrants you're sponsoring on this affidavit. Do not count the principal immigrant if you're only sponsoring family members entering more than 6 months after the principal immigrant. So here, people typically trip up because if they're submitting separate petitions for each of their immediate relatives, for example, a spouse and a child, a petitioner might want to put number 2 in the affidavit of support. However, you will only put number 1 because in this particular affidavit of support, you're only supporting your spouse. And then in the other separate affidavit of support, you will be only putting in 1 for your child. Moving on to part 5, household size. Make sure you don't count anybody twice. It happens a lot. Number 1, you will be putting in essentially the same number you put in to question 29 of part 3. Next, you obviously put in number 1 for yourself. Next, if you're married, it tells you to put number 1. However, this is very important. If you are sponsoring your spouse, then you will put 0 here because your spouse is the principal immigrant and you have already included them under number 1. This would apply, for example, if you are filing this form as a joint sponsor and you have a family of your own, then obviously you will put your spouse here because you're not the one married to the principal immigrant. Do you see what I'm saying? Next, same goes for children. If you are bringing a child from overseas, they are your principal immigrant. So here you would put a 0 for them. However, say for example, you immigrated here some time ago and now you want to bring your child, but in the meantime, you actually had another child in the United States who is now underage and is living with you. Then you will include your child here, just the 1. And the child that you will try to bring from overseas to immigrate here, they will already be included under number 1, okay? So please make sure, again, to not count anybody twice. And again, if you are a joint sponsor, obviously you will have to include your children here because it is important that you meet the necessary income requirement for the household, which will include both you, your actual household members, and the intending immigrant. Same goes for number 5. If you have dependents who do not live with you, but say for example, you claims them on your taxes, you will also include them here. Number 6, this can be tricky too. It says, if you have sponsored any other persons on form I-864 or I-864EZ who are now lawful permanent residents, enter the number here. So for example, you are a US citizen, your spouse immigrated here some time ago, and now they have a green card. But now you decide to also petition for your parents, for example, or your sibling. You will leave this blank for your spouse, who technically, yes, you're still their sponsor. Yes, your spouse still has a green card and you filled out their I-864 before. However, you have already counted them in number 3 under your spouse. So USCIS tells you to leave this one blank. This will only apply if you have not included this person anywhere before. And for number 7, if you are using any household members' incomes, you can put them here, but again, it's optional. Okay, so now you calculate the total household size here again, and I cannot stress this enough, do not count anybody twice. Okay, now that we have calculated the household size, let's talk about this part right here. Income you're using from any other person who was counted in your household size, including, in certain conditions, the intending immigrant. So here you would include, for example, if you have a spouse, adult child, sibling, or a parent who lives with you in the same household, and they would like to help you out as a sponsor, for example, you would include them here. A household member is not a joint sponsor. Therefore, a household member will not be filling out Form I-864. Instead, they will be filling out Form I-864A. A joint sponsor, like I said before, is someone who does not reside with the petitioner in the same residence, and therefore they will be filling out a separate Form I-864. A household member, on the other hand, is someone who resides with you. It is optional for household members to participate. For example, say you have a spouse and a child who is 18 years or older, they have a job, they're making money too, and they are both living with you still. And say you want to petition for your sibling, your spouse can say yes, but your child can say no, I don't want to sponsor, I don't want to participate. And that's okay, and they can do that. Next, let's talk about assets really quickly. Assets and income are different things. Income is reflected on your federal tax returns. An asset is something that can be converted into cash within 1 year and without considerable hardship or financial loss to the owner. If you are a petitioner and you're not making quite enough income, you can use assets to supplement that. And in that case, you may not need to have a joint sponsor. Another important thing is you can also use your household members' assets as well to meet the income requirement. However, there's certain rules. Again, read the instructions. They tell you how much the asset, what percentage of the total income requirement the assets have, because I think there's like there's special instructions for that, so please read those carefully. Can a joint sponsor, for example, use their household members' assets? Yes, they can. So the only thing a joint sponsor cannot do, like I said, is combine their income and assets with the petitioner and the other joint sponsor. But as a joint sponsor, you can use your income and you can use your spouse's income, for example. They will be considered your now household member, because remember, as a joint sponsor, you're filing a separate Form I-864, and on that form you can include your household members and their income and their assets. Okay. You can also use the intending immigrant's assets. There are very specific instructions on how to use assets to combine them with the total income. Again, it's all in the instructions. Make sure you read the instructions. For the intending immigrant's assets, that is also optional. You do not have to include that. Can you use the intending immigrant as a household member? Technically, yes, you can, but only under 2 conditions. First one is if the intending immigrant has the same principal residence as the sponsor, and the intending immigrant can establish that their income will continue from a lawful source even after acquisition of their green card. So this would be the case if the intending immigrant is already residing in the United States and they actually already have a job that will most likely continue, say it's a full-time employment, they have been working at it. And the other condition is the intending immigrant is the sponsor's spouse, and the intending immigrant can show that his or her income will continue from a lawful source, blah, 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 same thing. So it's either not a spouse, but they are living with the petitioner, or it is the petitioner's spouse. Okay, and really quickly, there's not much confusion in the form I-864A. Again, I-864A will be filled out by each household member whose income or assets you are using for the purposes of sponsoring the intending immigrant. Again, if you're not using any household members' incomes, you don't have to you do not have to fill out this form. However, please make sure that you are filling out and signing all the information on I-864A correctly, because as you can see on this form, both the sponsor and the household member have to sign it because it's a contract, right? So in fact, the sponsor's signature actually comes first in part 5, and the household member's signature comes second in part 6. So please make sure you do not mix those up. Finally, very quickly, let's go over when you would submit form I-864EZ, and also in what cases you would be exempt from using form I-864. So I-864EZ. It is an easier, shorter version of I-864. You may use this form only if you meet all of the 3 following conditions. 1, you are the person who filed or is filing form I-130, petition for alien relative, for a relative being sponsored. 2, the relative you're sponsoring is the only person listed on I-130. And 3, the income you're using to qualify is based entirely on your salary or pension and is shown on one or more IRS W-2 forms. So basically, if you are a US citizen, a petitioner, and you are petitioning for your spouse, and your spouse, you're a young couple, you just got married, and your spouse is staying with you, or your fiance is coming to live with you, and your income will be the primary means of supporting your spouse, for example, or if it's a child, it can be a child too. But if they are the only person listed on your petition for alien relative, if your income is the only income that will be used, so in that case, you will obviously be able to use form I-864EZ. And I'm actually really salty about it because it could have been my case, but I had no idea because I didn't know any of this. So hopefully this resource will be helpful to you. And again, if you open form I-864EZ, you will see in the first part, they will ask you these 3 questions, and even if one of them doesn't apply to you, they'll tell you to use form I-864. However, if all 3 questions apply to you, then you will continue using form I-864EZ. I know this video was very long, but I really hope that I cleared up some questions for you. I tried to give as many scenarios as I could. I hope that if you are also a joint sponsor, it was a little bit clearer to you as well. And again, I will appreciate if you subscribe to my channel. I hope you guys continue to stay safe. Have an amazing day wherever you are, and I will see you in my next videos. Bye.